Hi everyone, my name is Jen Hawkins. I head up the PSL planning team at LexisNexis, and I'm delighted to welcome you to this webinar on neighbourhood planning, which forms part of the Local Authority Insight series in association with local government lawyers. The aim of this webinar is to look at how successful or otherwise the neighbourhood planning system has been since its introduction by the Localism Act 2011 and what it might look like in future. It aims to cover the origins and aims of the neighbourhood planning system, how the courts have interpreted the role of neighbourhood plans against other frameworks and priorities, the effect of the expansion of permitted development rights on the effectiveness of neighbourhood plans, the difference in approach and effectiveness of neighbourhood forums between parish and town councils, how the approach of examiners has changed over time, and where neighbourhood planning fits in the future of planning law. So with all that said, I'm delighted to introduce our panellists today. We've got Sue Chadwick. Sue is a planning solicitor with more than 25 years of experience working with local authorities and in private practice, including project management of the Grand Arcade retail regeneration of Cambridge City Centre. She currently works as a strategic planning advisor with Pinsent Masons. Sue read English at Cambridge and has a PhD in planning law. Her previous academic experience includes lecturing for the Department of Land Economy, paper 14, and she currently delivers training for MBL seminars and the local government group of the Law Society. She is the author of In My Backyard, a practical guide to neighbourhood plans. And we've also got Stephen Morgan from Landmark Chambers. Stephen specialises in planning and related fields of law, having graduated in both law and planning. His experience both as advisor and advocate covers a range of planning and related topics, including major infrastructure projects, in particular waste and energy facilities, and related topics. His work covers the regulatory aspects under the various regimes and directives, as well as planning issues. This also includes extensive experience of village greens, highways, advertisements, heritage assets, and compulsory purchase and compensation for the private and public sectors. He covers hearings, inquiries, criminal and civil courts, including advising and appearing in judicial review and statutory challenge proceedings. So with all that said, I will pass over to Stephen, who's going to start the discussion on the origins and aims of the neighbourhood planning system.
Thank you, Jen. Good afternoon, everyone. It's nice to have so many listening and watching. If nothing else, I hope it'll be a nice distraction from Partygate, Inflationgate, and any other gate you might have that bothers you. So we hope we'll be able to cover matters that interest you, and we'll keep, as Jen said, keep an eye on the chat. We thought that as a kick-off, it would be helpful just to set the context reasonably briefly before we sort of address issues which go to the success or otherwise of neighbourhood planning. So really just looking at where neighbourhood planning came from and what were its aims. Perhaps just cast your minds back. There was, some of you may or may not recall, the Conservative parties, I stress that, open source green paper that came out before the May 2010 election, the election which resulted in the coalition government, of course. And we had there the embers, or the other way around if you prefer, of the bottom-up philosophy that Mr. Pickles, if you remember him, was putting forward. And we had Mr. Cameron's Big Society. Just worth mentioning because we're all, we're talking about reforms of the planning system all the time and levelling up. New system of collaborative planning, as the Conservatives then called it, not only looked at sort of neighbourhood activity, but it also talking about reducing the right of appeal. So you couldn't appeal if there was a conflict with a development plan. Think about that, and allowing a right of appeal, as they have, for example, on the Isle of Man, a right of appeal for against the grant of permission for neighbours affected. But that paper was actually looking at a more democratic community involvement in local plans, actually, when I look back at it. But when you then come into the Localism Act, which is a very wide-reaching act, the 2011 Act, of course, part 6 of that covering neighbourhood planning, which in many ways is a revolutionary approach to planning, which we'll be discussing, Sue and I. But it also introduced planning enforcement orders. Of course, it involved, as part of this bottom-up approach, abolition of regional strategies and replacement with the duty to cooperate. And one could spend an hour just discussing that, quite frankly, but we won't. Assets of community value were also introduced. But of course, there was the introduction of the neighbourhood planning provisions, which is what we're going to discuss today, how they've actually worked out in practice, just one point to reflect on briefly is in the forward to the 2012 framework, planning policy framework. It talked there, and this really sets the scene, the context, talked about a collective exercise. Planning should be a collective exercise, but in recent years, it's tended to exclude communities. And in part, it tells us it's been a result of targets being imposed and decisions taken by bodies remote from them. Well, has that really changed, you can ask? But that's what it said, and that's what its aims were. We look at the aims. And then when you turn to the briefly to the key characteristics of neighbourhood planning, I don't know what Sue thinks, but I mean, first point I'd make is the legislation is such a mess, you have to dig around different parts of it. And the main provisions actually relate to the orders, which is a minority of the neighbourhood planning activity, and not plans, which is the vast majority. So, I mean, once you're used to it, okay, but it needs codifying, quite frankly, but that's another point. But obviously introduce neighbourhood plans. And the key element for that, as we will discuss, is the fact that overlooked by many at the time, including many of my clients, was it is part of the development plan. And it's absolutely key. Once you and it took years for people to grasp that. And once you grasp that, you know, you can get to understand and work with the system. But it obviously introduced new language. I mean, you make a neighbourhood development plan, you don't adopt it, which throws everyone, including High Court judges. They still refer to adopting the plan. And you obviously have neighbourhood areas, neighbourhood forums, which we're going to touch upon. And so you bring in this whole new approach to planning to involve the local community for the first time, being able to promote a statutory plan. And that's obviously reflected in the MPPF as well as the legislation. So, Sue, I hope that gives some sort of flavour.
Yes, I do remember the idea of the big society, and nobody's talking about the big society any longer, that's for certain. But I think neighbourhood planning had much more of an impact than anybody thought it would, because as you say, the legislation seemed to be looking at these orders, and in fact it's the plans that have become the big issue in planning. And we're going to look at the specifics as we go through today, but I did just want to briefly sort of top and tail this first topic by mentioning the Levelling Up white paper, which came out obviously last week. And the first thing I did was, because I knew this was coming up, was see what they said about neighbourhood planning. So I did a search under neighbourhood. It came up 55 times, but most of those references were neighbourhood crime, and they need to do something about that. On the other hand, the Levelling Up white paper did say that they are thinking about a review of neighbourhood governance. They accept the importance of neighbourhood plans, but they also, and this is slightly going back to 2012, there should be more democracy. Everybody's aware now that neighbourhood planning has been a good thing, but for tending to be rural, well-heeled communities with time and resources to put into planning, it hasn't really benefited the range of communities that it should have done. On the other hand, at page 225, the Levelling Up white paper says there are already 2,800 neighbourhood planning groups. So it has clearly been a success, and one of the, I think I was saying last week, maybe the only thing where there is cross-party support left. The idea of neighbourhood planning is the only thing about which most people in the Parliament will say is a good thing. So that seems to be a reasonable place to move into topic 2, which is where we get into the pretty heavyweight law. And because this idea of how have the courts interpreted neighbourhood plans against other frameworks, it's a massive topic. So we've slightly decided to put it into 5 subtopics. First one, compliance with strategic policies is one of the basic conditions, and it's fair to say it's taken up most of the court's time. What does that mean to be compliant with the strategic policies in the superior plan? Then we're also going to look at strategic environmental assessment, how that's affected plans, a little bit of a look at examiner reports and reasons, interim injunctions, the sort of more technical side of things, and again, the technical side of things, the time limits for a challenge, which is, I think, the only time when the neighbourhood planning system has got to found itself in the Supreme Court so far. So the first subtopic really under topic 2 is compliance with basic conditions. And this one really kicked off, I think, probably right, the Localism Act 2011, people started making plans. And then after a couple of years, developers realised that they actually were a part of the development plan and could be a problem. And we got our first case, which is BDW Trading and Cheshire West back in 2014. And this looked at what does that test mean? And it's a very early plan, and the judge in that case just simply said, unlike a local plan, which needs to be consistent with national policy, an examiner needs only to have regard to national policies and advice when deciding whether it's appropriate to make the neighbourhood plan. So quite a laid back approach. And Stephen, you were saying you would like to mention a couple of cases here, Crown Hall Estates and Kebble Developments. And I think those are two very useful ones because they came through 2016 and 2018. So they give you an idea of how things moved on after that from that BDW case.
Yes, I mean, absolutely. And I'll just touch upon those in a second. Just something perhaps I should have made clear at the outset is, of course, as Sue has made clear, a neighbourhood plan is a part of the development plan, but the tests are different. It's not soundness, and this is really what's come through in all the cases and led to the importance of neighbourhood plans in many different dimensions. But it's the basic conditions, as you refer to, Sue, in paragraph 8.2 of Schedule 4B. I'm sorry to talk about
well remembered.
Got it right. Saying earlier, it's quite difficult to remember all the different areas, but it's absolutely critical. And the case that Sue refers to reflects that. And the Kebble case is a mystery to me. It's still a mystery to me because that's to do with, I think, basic condition 2E, general conformity with the strategic part of the local plan. And basically in Kebble, you had a neighbourhood plan that was supporting a site and hoping that it would be made greenbelt in the future. This is in the locals. And in the local plan, you had it, it was effectively a protected area of search, an earmark for housing, it had been, and it was hoped to be for housing in the future. And so there, to me anyway, putting a planning hat on rather than a legal hat on, there was a conflict. But the High Court judge and the Court of Appeal disagreed and basically says just because you know that there might even be some tension between one policy, and we're talking about an allocation here, in a neighbourhood plan and that in the local plan, that doesn't mean it's in breach, and they take a very flexible approach to general conformity, which is really what BDW set the seeds for. And the other case you referred to was one of the earlier cases, Crown Hall, that in I think it was the Loxwood neighbourhood plan in West Sussex. And there, I note that one because Mr. Justice Holgate very much took on board it was the locals plan. They did an alternative site search, which may not catch muster at local plan level and a local plan inspector, but was found to be satisfactory at the neighbourhood plan level, which again exhibited the way that the courts approach it, and it's based on the legislation. The legislation is very flexible and wide. So I thought that was important. In that case, Mr. Justice Holgate also made interesting comments about, remembering it was, I think, 2016 or thereabouts, set the scene for the much more flexible approach, the lower bar for neighbourhood plans, which developers had to get used to, quite frankly.
Yeah, I had a look at that again this morning, and although it's 6 years ago now, I think it's still a useful case because he says he looks at paragraph 8.2 and he says it's not to be confused with the more investigative scrutiny required under the test of soundness. And I think that's such a useful phrase to have in your armoury if you're dealing with that kind of an issue.
Absolutely.
Now, I know you mentioned Abbey Properties, and I think we've definitely got space to mention that one and a couple of others. But the one I definitely wanted to talk about in this topic is DLA delivery, because that was one where we'd had and this is DLA delivery, and it's 2017 case, and it's a Court of Appeal case. And I think why this one was so important was up until that point, you'd had this basic tension between strategic policies in a local plan, neighbourhood plan policies, how did they fit together? And then you had this case that really brought issues into the arena, because in this case, the local plan was way out of date and in effect had no strategic policies. And the developer argued that it was a misapplication of that test of conformity to say that a neighbourhood plan was in conformity with a superior plan when there were no superior policies to be in conformity with. And I think it's so good that we had the Court of Appeal, Keith Lindblom, looking at this with his usual kind of sense of magisterial sort of clarity, and he just sort of pulled the whole thing together and talked about this issue in great detail. And he said, yes, it's required to be in general conformity, but sensibly, the true test of in general conformity is simply that if there are relevant policies, then you have to be in conformity with them. If there are none, then you adopt your plan anyway. And if the local authority then brings in a local plan where there's a conflict, you're the one that's out of date and your policies start to become material considerations. And it was, for me, this was the big case about how local plan policies and development plan policies fit together. And I don't know about you, Stephen, whether that was the same.
Absolutely, it's an absolutely critical case. And it exemplifies the difficulties you get in matching up housing, if you like, and the requirements that are, should be in the local plan, where you don't have an up-to-date local plan. I mean, one of the University of Reading recommendations, they're the body who produce very interesting and empirical work on neighbourhood plans and advise and report to the government, certainly have recently. But they say that consideration should be given, and you'll smile at this, but consideration should be given to requiring neighbourhood plans to be reviewed every 5 years like a local plan. We all know the difficulties with local plans, and in theory is a great idea. And, it should happen. There should be some parallel process, in my view. But whether in practice that's ever going to happen, who knows? And we don't quite know where we're going with local plans anyway. But can I just, DLA delivery, you're absolutely right. Yeah. Very hugely important case. But just one other quick little side story, if you like, on that one is that what was happening at the time, and I remember this quite well because I had many unhappy clients. Or unhappy local people, actually, but they were getting fed up with examiners on the whole seemed to be just upholding neighbourhood plans. I mean, I think that was because of a lack of understanding of the low bar, and they were learning like everyone else, to be fair to them. But there was a challenge on the choice of the examiner, challenge because it can be chosen by the local, it is chosen by the local authority and the promoting body. Whether that's a forum or parish council, and they challenged that in the High Court and lost. They challenged it in the Court of Appeal, said it's unfair, and so on, and it got very short shrift. He said that's what the statute says you do.
But I think that does kind of open up the problem with neighbourhood plans. They have such an impact, and yet there's not very much guidance about them.
No.
Not compared to the local plan. There's nothing like the PINS guidance. There's nothing like the detailed NPPG guidance on soundness. If you are either making a local plan or seeking to overcome its policies, you've got to sort of make it up as you go along to a certain extent. But yet it has this effect, it has this impact, it has this status.
Yeah, I agree with that. You have to dig quite deep for guidance, including the independent inspectors, which will come on to that guidance on that, and also Localis have a series of papers. Those who are interested, you have to dig deep. I'm trying to take your point about sort of national guidance, because I think it is intended to keep it fairly flexible and low key and not too pedantic or strict. I think that's the aim, but of course that has consequences.
Yeah, especially when big developers realise that they might. I think it's sort of tied in with sustainable development, that you had this sort of idea that the local plan's out of date. Therefore, the presumption in favour of development applies here, and I've got my housing site. And then, oh no, the neighbourhood plan pops up, and that one is up to date, and has some difficult policies in it. And then suddenly, the might and of the developer was applied to the neighbourhood plan. And as you say, we're all then dealing with a kind of much wishy-washy sort of environment when it comes to policy. And yeah, it's been an interesting conflict there.
Absolutely interesting. Because if you give more power to local people, as some would suggest, even more than now, then you've got to understand the consequence of that in terms of delivery.
Now, aware of time, and I think we should probably go on to SEAs, but I don't know whether you wanted to mention anything else before we do.
Let's go to SEAs.
Yeah,
because all of these cases cut across each other anyway.
Yeah, they do. Okay.
So,
and I think we've talked so much so far about cases where they were challenged and challenged and challenged and no success. This, I think, the Stonegate Homes case, which was 2017, is the standout example of a neighbourhood plan that was overturned. And again, it overlaps with what we've been saying. You have to dig deep into the schedule, into the basic conditions to find that condition that says conformity with European policies, which is a very vague term. And what it meant in effect was you had to be in conformity with the relevant EU directives, including strategic environmental assessment of plans and programmes. And that's what came out with the Stonegate case, where they had thought about alternative sites for what they had designated, but they said, no, we can't have that because too much pressure on the road network. And when this was challenged on the basis that it was inadequate for the purposes of the SEA, the judge agreed, and I don't know who the judge was in this case, you might remember, but he or she said it was unsupported by anything other than guesswork. And it sounds like Lang. I don't know why. It just has that sort of feeling about it.
I'll be honest, I can't remember. I should.
Okay. But that judge said it's incumbent that the NDP is compliant with retained EU obligations, obliged to undertake an objective assessment, and alternatives need to be accurately presented in order for the SEA to comply. So you have. That was the point at which people have been cantering along quite happy with the fact that a development plan, a neighbourhood plan, would have a fairly relaxed approach from the courts. And in this case, the court said, no, we're not relaxed at all. You really do have to comply with SEA, and that means doing certain things in a certain way, and there's no flexibility here.
That, as you said, limited success. To the best of my knowledge, there have been 2 out of probably at the time this statistic came forward, which is a few months ago. There were probably over 900 made neighbourhood plans. There had been 2 successful challenges, and one was the Horsham, the Henfield neighbourhood plan in Horsham. That's the Stonegate one, which I'll just comment on briefly in a minute. And the other one we are going to mention is the Norton, I think it's Norton St Philip neighbourhood development plan in Somerset, which is the Localism case.
Which is actually next in my notes too. So yes.
On Stonegate, I think that it's interesting because there was the SEA requirement, and then you immediately engage the jurisprudence that applies to that, and therefore alternative sites becomes a slightly more rigorous approach. That has to be applied, as you'll be very familiar with, and hopefully others listening are familiar with. But that's so it is important. But in that case, there was a black hole. I mean, they basically locals didn't like the claimant site, and this is the truth of it. Claimant site, so it was knocked out on access, and there was no access had been dealt with, and there was no evidence. It had all been agreed by the consultants, and therefore there was a huge hole, and therefore that's why the got quashed. And it was one of the more obvious ones. Once you engage, the SEA requirements, and there was that black hole. There wasn't sufficient, as there was in the Crown Hall case. It wasn't sufficient there to get them home.
But we've mentioned it before, and I think there was a black hole in the guidance too. And I think the guidance was subsequently updated, the NPG, to say, oh, by the way, if you're making a neighbourhood plan, then you have to do the following. You have to have this sort of an assessment.
Yes.
Why the sort of there is that question mark of, if you're bringing in neighbourhood planning, then you really should be bringing in guidance that says, and when we mean comply with the EU obligations, we mean you do an SEA, and this is what you need to do. So that you can see that the gap in that original guidance did have consequences.
And there's a gap now, I can tell you, in because I was asked yesterday by a colleague about this. There's a gap in the PPG advice about when you need an SCA, because you need an SCA where there's going to be harm to, where you basically need an appropriate assessment, and that's not clear from the guidance. So you're absolutely right. There are practical, everyday issues,
questions that don't get answered.
Underline, if I may say so, your point about the need for more specific and clearer guidance to help.
Yeah.
But if you go to the part, sorry, if you go to the because I did actually check this yesterday because it was raised. If you go to the Localism practice guides, they have it, to be fair to them, they have it all spelt out. It makes it clear there that you need it. So that's how I'm, quite frankly, always cross-check myself. Sorry, we're going to say.
No. But we both mentioned the case with Mendip, which brings me on to our next sort of subtopic, which is examiner reports and reasons. And I think this is one of the two that you said that where there was a successful challenge. And this was another Court of Appeal case where but in this case, it was successfully challenged. Because the examiner had departed from national policy and had on local green space and the green belt and had not said why. And Lewison said there was not this was not an inappropriately forensic analysis of the report, but rather there was a gaping hole. So it's rather like he was saying, there's just an absence of reasons. And this is one of the areas where you have found that you can be as fair as you like, but that report was just inadequate. And I think that's you can contrast that with Abbey Properties, a much more recent case where they said, look, the examiner's report has to be read fairly and as a whole. The standard of reasons is the general standard. You've just got to explain why you did something. Now, in the Abbey Properties case, the examiner's reasons were held to be absolutely fine, but you do have to have some kind of reason. You do have to address the issues if you're an examiner looking at a neighbourhood plan.
Can I comment?
Yeah, do please.
I'm aware of the time, but there's two. Yeah. I mean, you're absolutely right. In local law, I mean, as you say, the policy included, which was upheld in the High Court, I have to say, which is Justice Lang, which is interesting. The policy in question provided that development on local green space would only be permitted if it enhanced both the original use of the site and the reason for its designation. Now, that's a higher test than the Greenbelt test, which of course is applied by, I think, paragraph 101 of the framework. So you're absolutely, and there was no reason for having a stricter test. The Court of Appeal said, if there's good reason, you can depart from national policy. A tenet and approach we're all familiar with, but it wasn't, as you rightly said, so it wasn't actually given. So that was the essence of that case. Court of Appeal coming in to the rescue in that sense. And in Abbey, the only comment I make on Abbey, why I find that particularly interesting, is that in that case, the local plan inspector had considered the local green space designation for the site, for the claimant's site, and her, I think, must have been in her interim report because she didn't do a full report. Because the plan got withdrawn before she could do it, but she had given out her main recommendations, which were to remove the designation. And in essence, the neighbourhood plan just took a completely opposite approach and designated it. And the claimant got very upset about that. They couldn't get the inspector to provide, the local plan inspector to provide any reasons, because she said, I'm going to use a terrible Latin phrase, she was functus, otherwise she had no more role because it had been withdrawn, which is right. And the court, as you say, they were happy with the examiner's reasons and that. But that is an interesting case. You can understand why the promoter was peeved.
Unhappy, yes. And I think that brings us on to the final subtopic of our second question, which is the time limits for challenges. And, it's again one of these subsections of a subsection that people hadn't thought about too much until we had the Filed Coast Farms case,
yes,
which went all the way to the Supreme Court. And what I had to look at it myself again when I knew I was doing this. And I think what the Supreme Court clarified very, very carefully is that you have Section 61N inserted into the Planning Act, and it provides a number of different opportunities for challenging a neighbourhood development plan, but there are 7 steps in making a development plan, and they had basically tried to challenge step 7 using to challenge step 5 of the plan process using the wrong subsection of section 61N. And you know, I read it fully the first time and had to explain it to our team. I had to read it again last week. I may not have given the clearest definition right now. And that brings us back onto, you know, how are local groups are meant to, you know, or local authorities for that matter, get to grips with all of this quite complicated stuff and get it right all the time. I don't know what your thoughts on that are, Stephen.
Absolutely. I mean, the importance of filed is, you're absolutely right, is to you know, be very wary that you have to make challenges as you go, which is what they fail to do. And it's unlike local plan process, where it's more, as the Supreme Court said, and you're right, to the best of my knowledge, it's the only neighbourhood plan case that has gone to the Supreme Court, as far as I can recall. What I thought was, in addition to that procedural point, which I think is very interesting, which in a sense, as we're ending this topic, pulls the threads together. If you read the speeches in the Supreme Court, it ties together the court's approach and underlines sort of DLA approach, because it reaches its decision on the basis you shouldn't undermine the democratic process. And I mean, I don't necessarily, with respect, agree with what they say about the likelihood of challenges when you look at the statistics, but they're saying, you know, there shouldn't be this sort of hanging over a referendum, to wait to the end of referendum, you know, because they said Parliament was entitled to strike the balance it thought was right, and it did so, clear enough from the legislation. And they said that the NDPs are the product of separate legislation and local plans, with the promotion of local democracy primarily in mind, and critically involving the holding of a referendum. So, you know, they very much, as the courts have given, you know, substantive weight to the whole origins and aims of the local planning movement, quite frankly. And overridden sort of procedural niceties. You know, wouldn't it be better to wait to the end? I mean, because that's what happens in a local plan. They've overridden that on that basis, which I thought was interesting. But I think it's very important and revealing as to the, you know, approach of the courts to such challenges and to neighbourhood plans.
And for anybody that's thinking, gosh, they've been half an hour and they've only got through 2 topics, the next few topics we do intend to take a little bit more quickly, because there's not quite as much in them.
We had a question. So, I mean, I must.
Right. Go on. We have been talking, haven't we?
We had a question about how early should I may not have got the gist of it because it was just flashed through, but how early should you carry out an SEA? And funnily enough, I was reading yesterday, the guidance I referred to said as early as possible, which makes sense.
Right. I actually saw that one come through, and I was thinking about that, and I thought, it isn't. I think that the thing about an SEA, it's too easy to think. I think particularly with a neighbourhood plan where you've got challenges at various steps, do not think of it as a one-off. Start doing the SEA thinking as you draft the plan. And as soon as you have any notion of what the environmental impacts will be, do some kind of an assessment, so that when you submit it, you can then build on those early thoughts and those early assessments, put in at that stage a better assessment. But I think the big mistake at that point, particularly in the kind of world we live in, is to think that you've done your job. I think there's a really good case for coming back to the SEA.
Absolutely. You've got to monitor it all the time. I completely agree, and that's I think what that practical advice says as well. So yeah, absolutely. The other question I saw also was, in essence, you know, can you depart from a neighbourhood development plan? And the answer to that is yes. It's part of the balancing exercise. Yeah, frustrates local people. To say, and can I just mention, they can be put on the list. I know Lexis will. I'm not going to refer to many detail because we haven't got time, but there's 2 cases which go completely opposite way. There's Langmead and there's Southbourne neighbourhood plan, which is the Chichester case. We'll put them up, but they are crucially important if you're looking at the correct approach. And in essence, the providing the usual public law criteria met, you can have a lawful decision that grants permission, and on the same case you can have one that one doesn't. It's a planning judgment. I mean, that's the approach. So yes, you can depart as long as there's justification to do so. Sorry, Sue. I mean,
no, that's fine.
Trying to
I think it's you to kick off on permitted development anyway.
Okay.
But now on to topic 3, I think, of the ones who we're going to look at. Yeah,
I mean, permitted development, in a sense, is an element of the antithesis, and I'm quoting this from one commentator, of localism, in the sense that you're deregulating, and therefore you're I appreciate that it's, questions of degree and nature and circumstances, but in essence you are deregulating. So we know the general debate about, some people have concerns about some of the PD rights, the effect on town centres, the allowing of building upwards or even clearing sites now. I'm not going to go into any detail, we don't have time, and this isn't the right forum for that, but there's general concern about permitted development rights. There's ways of avoiding those which are limited. There's some control for some permitted development rights, and many permitted development rights, in terms of prior approval. And Sue and I are going to mention a case in a second, a recent case. And there's also Article 4 directions, but they've been more difficult now. The government's made those. And there's always also the risk of, the 12-month time point and compensation. So it's a cumbersome and difficult tool to try and stop them. But with regard to then looking at that in the context of neighbourhood plans, there's no special neighbourhood planning powers which allow you to curtail such rights. I mean, it is the general right. So there's nothing. So the effectiveness on neighbourhood plans is as like on local plans in a sense, and it will frustrate local people. They see shops disappearing and so on, beyond just what they might think is the norm. Just one point that we mentioned, as I say, there is this case Sue I know wants to refer to, the CAB housing case, which in essence was dealing with the upward extension, I think Class AA for shorthand.
I mean, what I would say is it's not to do with neighbourhood planning, but for anyone who finds themselves utterly frustrated by the way in which PD rights are imposed and non-negotiable, I think I think it's Holgate, yes, opened this one right up I think it was 23rd of February, so not very long ago. A case just last week where he was looking at what a local authority could take into account when granting a prior consent. And I think he said I could go on about this for ages, but what I think the key points are that he said permitted development rights don't give you an absolute right to do anything you like up to the level. They just set the outer limit of what you can do, and that this can be constrained by the local authority when it grants the prior consent. And also that the local authority can look at wider amenity considerations that are not limited to the impact on neighbouring properties, and that you can give wider considerations to all relevant aspects of appearance. And for me, he's opened up a lot of amenity considerations, a lot of design considerations, and in a sense allowed local authorities to use prior consent to reduce the scope of PD through that prior consent process. I think it's quite a big case.
It's a very big case, but and it brings into question how valuable PD rights are in some circumstances over a permission, because you can bring in broader issues. Obviously you have to look at the particular wording of each permitted development right. The other thing I think it brings into play in the context of what we're discussing is there could be a role for neighbourhood plans, I guess, in terms of those matters that can be controlled through prior approval. Whether there's room to have a neighbourhood plan policy, obviously dealing with the particular characteristics of their area, because they are encouraged, of course, to be involved both at the local plan and the neighbourhood plan with the with the new design regime. Very much part of neighbourhood plan approach there is encouraging design, both contextual assessments and policies in neighbourhood plans. So there could be a role there. That's all I would say. That's the only sort of link I can see. But I agree with you, it's an important case broadly as well.
And I think that brings us on to the that difference, if you like, between neighbourhood planning promoted by town councils and neighbourhood planning promoted by the sort of the specific neighbourhood forum. And I've got a little bit of experience on this because I live near Canary Wharf, and I worked on the Isle of Dogs neighbourhood plan. And from a personal point of view, I think forums can definitely be more agile. You often have a lot of ground level enthusiasm from people that don't usually get involved in planning. On the other hand, and this is relevant to everything we've been saying, neighbourhood forums tend not to understand the planning system. They don't understand that one planning judgment can go one way, one planning judgment can go another, and it doesn't, and neither of them may be wrong. They're just a planning judgment, and they don't understand as much how local authorities work, and it can be quite a bad tempered process. Not that I'm saying parish councils are any better tempered, but just trying to explain that how planning works. You waste a lot of time in a neighbourhood forum, I think, doing that in a way that you don't so much with a parish council. I haven't got much more to say about that, though I know you did want to mention the Airbra case here with the designation and the way that the judge looked at that.
Yeah, a couple of things to say. On Airbra first, that was there were a forum were seeking to challenge a local plan. The forum's role in terms of the neighbourhood plan had come to an end. I think at the time of the challenge they were undesignated actually, but they were designated earlier on. And in essence, the council said, well, they're not, a person aggrieved. They can't make the under Section 113 of the 2004 Act on the local plan. And to put it very shortly, the court said no. They were clearly an unincorporated association, but nonetheless they can be a person aggrieved, and they had an interest and gave a legal status. So I think it's quite important to forum, because of course a parish council could have done, or a town council. That's the first thing I would just highlight. The second thing I would highlight is that clearly, and I think one of the comments that we've got makes this point. I mean, there's clearly a funding issue going on here. Talking generally, not just forums, but there's clearly problems with funding, with the grant availability of grants, ceasing, I think, in terms of the technical assistance. I always thought that forums, I mean, have been grants available. One of the things that the Reading University is recommending to the government is funding, particularly they say for deprived, increased funding, particularly for deprived areas and for forums, or 4R, depending on your view. There's a big issue there, and I'm not being disrespectful to the question, dealing with it relatively shortly, but there is, I accept, a huge issue for forums as well as parish councils. And parish councils they have more access to, assistance and so on, but
I did see part of the just before the levelling up white paper came through, there was an announcement that there would be more funding, but I look at the detail and it says up to £45,000 to 7 areas, which is not a lot of money and not a lot of areas, though it is good to see that they're targeted at the less privileged areas. I'm looking at where it was, and it was Middlesbrough, Tower Hamlets, though I don't know whether they want to put any more money into the Isle of Dogs plan, Leeds and Bassetlaw. So it's it's a nice kind of sample, but it is no more than a sample.
Can I just say one other thing? Just put this debate or discussion about parish, town council and forum into context. 94.3% the Reading work tells us, so 94% of made plans were led by a parish or town council, and 5.6%. But when it comes to business-led plans, there are 22 business-led neighbourhood plans, 20 of which were forum-led.
Wow, right, so it's a different,
local business community getting involved. I've done one actually, and 2 were parish town council led.
Interesting.
Okay, so if you're happy, Sue, and we've dealt with that one, we move on to the issue of the approach of examiners, and whether that's changed over time. Well, I mean, like all of us, I suppose it's changed in one sense, is that everyone's getting more familiar with how to apply the legislation and what guidance there is. And there's also been the NPERS for short, the Neighbourhood Planning Independent Examiner Referral Service. They put out a document, I think it was about and I think Sue thinks 2015-16, thereabouts. So not right at the outset, setting out, the guidance on the examination process, the procedure, the procedural legal requirements, the basic condition requirements, and which is very helpful. And I would have thought, brings a certain consistency between examiner, and no, it does actually. If you look at them where they're involved, which I think is the majority of cases. So I think that's happened. And I also remember talking on the subject a while ago, and there was a 2016 article, sort of, I suppose, halfway through the process, when things was just beginning to settle down, and neighbourhood plans, actually, if you look at the graph, was beginning to leap upwards. The question was, this was in Planning magazine, were examiners setting a higher bar for neighbourhood plans? Because there had been there have been 3 refusals, or 3 failures, if you like, at examination. And John Parmiter had done the Wantage neighbourhood development. I remember this, actually. He expressed concerns about extensive protectionist policies and proposals. But in essence, I mean, I don't think there's any great change of approach. There might be a more sophisticated approach in terms of housing, the understanding there of the tension and then, the need in the NPPF, as the government has sought to highlight, that neighbourhood plans should be at least taking that on board to some degree. But ultimately, I mean, you've got to, they will fail if they fail to beat basic conditions. They haven't had proper regard to national policies and advice. And they're not in general conformity with European obligations. In essence, I'm being very simplistic, but that's what the examiners will tell you, and that's what they supported as saying. And indeed, look, I mean, we've got time, but I can give you recent examples where the problem that's arisen is because of the problem of a withdrawal of a local plan, and that led to the policies in the neighbourhood plan. This was actually Saffron Walden. The policies in the neighbourhood plan, they were relying largely on allocations from the local plan. This weren't separately evidence-based, and the examiner has pointed that out. So that's not some sinister approach to cut back on the neighbourhood plans. That's just an application, of usual criteria. And if you look at the again, sorry to go back to it, but the Reading University, they talk about 9 neighbourhood plans had failed examination, and 6 failed referendum, and 1 had been quashed in the High Court. That was the Stony Cat at that point. We've had all since then. So it doesn't seem to be any huge difficulty in that sense. And indeed, I think a lot of people would see the opposite, in terms of the development industry, see they're going through too readily. But that is, as I say, that's the legislation allows that, as discussed in the court cases. So unless there's anything else you'd like to say on that, I think we can move.
That's perfect time, actually, and a couple of really interesting connections with the last topic, which is a big one. Where does neighbourhood planning fit in the future of planning law, whatever that will be, and how do they need to change? Well, obviously, this is a discursive rather than a legal point. There's cross-party support for neighbourhood planning. There is grassroots engagement. I can't see the government walking away, any government walking away from neighbourhood planning because of those 2 elements. I think that neighbourhood plans will face the challenge of climate change, just as every other plan will, and eventually these cases that are coming through and bubbling will be successful. Digital planning is another thing that's coming through, and I think that's where neighbourhood plans could be more agile, possibly have more knowledge, particularly if you have the right people in the right village. They could have the right sort of knowledge to break something more digital, more agile than the local plan. But there's also new challenges coming through. Planning is always subject to challenge on the basis of human rights and equalities. The neighbourhood plans are not going to be exempt from that. There was one where they tried to get Article 8 of the Human Rights Act through on a case in Cornwall, though it was unsuccessful. But I've seen 2 cases in the last year talking about Article 10 and freedom of speech and councillors and parish councillors. So that's bubbling away in the background as well. And on that point, I did want to bring everybody's attention to a case that doesn't often get mentioned in the context of neighbourhood plans, possibly because it's about 100 pages, and I think people get to page 50 and give up. But it's a case in London where there was a designation of green space by Neighbourhood Forum that was challenged, as you would expect, by the owner, because it was worth millions if it was ever developed. And he went to town. He didn't just challenge the allocation, he alleged bias on behalf of the and pretty much everybody. He said the inspector was biased, and it was John Parmiter, and you just mentioned John Parmiter, who's an experienced examiner. He said there'd been collusion between the neighbourhood planning body and the local council. He said the council had gone too far, was far too sympathetic, and Dove does an extraordinarily detailed examination of all of those issues. So if anybody's got any questions about probity to do with their plans, I would highly recommend picking up this case from about paragraph 109 onwards and having a look at it. And we also mentioned, Stephen, the NPA's guidance, and Dove very much relied on that as a piece of in the absence of anything from government, as a piece of really sound guidance as to what to do and how to do it on probity as well as on content. And that's really where I see things going. They'll have all of the same challenges and opportunities as planning, but I think to forget about either climate change or digital planning or planning probity would be a mistake at this stage, because I think those are all big issues that the planning system is dealing with now.
Yeah, I mean, I think I agree entirely. I think you make important points about the particular issues and human rights and so on. And I also completely agree that neighbourhood planning isn't going away. And far from it, because every reform they always refer to, neighbourhood planning will be there. It's
a good thing.
Be there. How it would be in zoning it would have been or would be in zoning. It isn't. I think that's probably why they backed off partly, because the implications for community involvement. So, quite where that would have gone, I don't know. So we're a bit, as you say, in the air on that at the moment. I think what's important, I mean, certainly the University of Reading, again, because this obliges the government, so they say, well, there's arguments for and against it, and it's really, and I'm paraphrasing, this isn't their wording, but essentially they say if it's going to be worthwhile overall, then there needs to be some significant changes, and those significant changes cover what we touched upon earlier, in terms of funding. There's this big issue, 50 shades of planning, big issue about local authorities, planning authorities, having the ability, the resources, the enormous pressures they're under now. And if you read that blog, Simon Stamford, I can't remember, but that blog, which is very revealing, some of those problems have come with neighbourhood planning. It's all well and good people criticising, and I've been in situations, but the local planning officers often haven't got the resources all the time. So that's a big issue as well. There's huge issues that if you're going to have this and the role it plays properly, but I mean, you're going to have to fund it properly and give the specialist advice and guidance that you referred to earlier. So there's, we could spend a long time on the future, but it's to say quite in what shape or form and how it will reflect housing need is still, I think, very much up for grabs.
I think we finished exactly on time. Jen, do you want to spotlight any questions?
Thank you so much, Sue and Steve. That was a really interesting topical discussion. I think we've just got time. I know you've dealt with some of the questions on the way through. Maybe just got time for a couple of very quick questions. Firstly, have you seen a really good policy for managing development within a local green space? Trying to make a single policy consistent with NPPF policies for green belts is a challenge.
I have seen, I couldn't read it off the top of my head, but the ones I have seen also tend to mimic the Greenbelt approach about openness as well. The ones I have seen and go through. I mean, the answer is there are some good ones, but they do exist. But I wouldn't like to just off the top of my head give an example. I know neighbourhood plans, but I think the ones that respect the NPPF, the criteria there, and don't, then the point that we've gone back to earlier is they need to be consistent with the greenbelt policy and not be stricter. They a lot of them I've seen over, or certainly in the earlier stages, over egg, as you know happened, as we pointed out earlier. They over egg the policy, so they've got to be careful.
I think that's a really good point. And given what we talked about with those earlier cases, if you were drafting a policy, I think the sensible thing would be to say, you know, here's the basic part of it. This is the part of it that we are happy is in conformity with the NPPF policies. These parts of it are advisory or subsidiary, but are good guidance. They should be regarded as part of the plan, but to accept that they're not overriding the Greenbelt, and even to say that, whether it's in the policy itself or in the document that approves adoption of the policy, to say, there is no intention here to be overriding the NPPF policies. We want to be seen to this as complementary to them, because that's what green spaces are. They're not the same as green belt.
Okay, thanks so much. And maybe just time for one last question, if that's okay. Just someone commenting that they had to produce a scoping document prior to an SEA, which they commented was very time consuming and needed to be reviewed. Was this just time wasting?
I would say no, from what we said earlier, that the earlier you grapple with the SEA points, I know it's time consuming. I know it's annoying. It's a point we had on the Isle of Dogs as well, but you're just building up a really good audit trail for any future problems. The more work you do in the earlier stage with an SEA.
I agree. I think any plan where there's allocations, you've got to be very careful in particular. And these days, plans are supposed to be positive. So I agree entirely. I think, in short.
Okay,
probably not the answer you wanted, but sorry.
It will depend. Yeah, I mean, there may be, oddly enough, as I said earlier, I was one yesterday I was considering, but there may be exceptions. But as a general approach, I absolutely agree.
Thank you so much, Sue and Stephen. I think we'll draw it to a close there. Sorry if we haven't had time to answer all of your questions, but like I said, we will consider it for future content. And just to remind you that we'll send you a link to a recording of this webinar together with some relevant content. And just to say thank you so much to our speakers and to everyone that's signed up. Thanks for signing up and listening and asking all your questions. Thanks so much.
Thanks.
Thank you. Bye.
Bye.
Bye.